So friends, in the wake of the Supreme Court telling federal judges that they can't use nationwide injunctions to protect we the people against Donald Trump's unconstitutional revocation of birthright citizenship, federal judges have found a new way to protect the people: class action lawsuits. So here's something I'd like to focus on today. Federal judges are protecting us, protecting we the people, against a president of the United States who abuses his power and acts unconstitutionally. Federal judges are protecting the people against Donald Trump's abuses. And that, my friends, is a point of light. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, you probably already heard by now that a federal judge, Judge Joseph LaPlante, just certified a class action lawsuit protecting every child in America who was born after February 20th, 2025, protecting them against Donald Trump's lawless attempt to use a Sharpie to cross out, revoke the constitutional guarantee of birthright citizenship. And Judge LaPlante issued a preliminary injunction protecting all of those children against Donald Trump's abuse of power. Now, friends, what I want to do today is focus on three short, discrete passages from Judge LaPlante's 38-page ruling. And, you know, this is not necessarily what corporate media is focusing on. But as always, let's start with the new reporting. This from the Washington Post. Headline: Federal judge places new block on Trump's ban on birthright citizenship. And that article begins: a federal judge in New Hampshire on Thursday placed a new nationwide block on Donald Trump's efforts to end birthright citizenship, a decision that came 2 weeks after the U.S. Supreme Court tried to open a path for the administration to begin enforcing the order, the unconstitutional order. My editorial addition. During a court hearing, U.S. District Judge Joseph LaPlante agreed to a request from civil rights groups to certify a class action lawsuit against the Trump administration on behalf of U.S.-born children or future children whose automatic citizenship could be jeopardized by Trump's executive order. In a written order, Judge LaPlante said the petitioners are likely to suffer irreparable harm if the order is not granted. The decision represents a fresh setback for the Trump administration in its efforts to begin implementing Trump's executive order that would deny automatic citizenship to the children born in the United States to unauthorized immigrants and foreign visitors. Some studies suggest that more than 150,000 children each year would be affected. Oh, and by the way, Judge LaPlante was appointed as a federal judge by President George W. Bush. Okay, friends, so let's turn to Judge LaPlante's order. And as I mentioned, I want to take up just three discrete points in this 38-page order. As you can see, I've tabbed it up so I can take the points in a particular order. I'm going to try not to screw that up. Now, I'll probably screw it up. Don't worry, we'll edit all of this out. Probably won't. But let's go through just a little bit of Judge LaPlante's order. And it's in the case of Barbara, that's a pseudonym for one of the children, Barbara et al. And others versus Donald Trump, President of the United States in his official capacity, and others, order granting preliminary injunction and provisional class certification. And friends, you might ask yourself, well, Judge LaPlante's order covers all children born after February 20th, 2025. That's the date of Donald Trump's unconstitutional birthright citizenship executive order. But what about the children who haven't been born yet? Judge LaPlante has got that covered. Turning to page 11 for those of you scoring at home, when the respondents, the Trump administration, object to the inclusion of future persons in the class, arguing that future persons, i.e. persons who have not yet been conceived, lack either standing or capacity to sue, the judge says, although the future class member children in this case have yet to be born, as soon as they are born, they will join the class and their claims will be ripe. And in the face of the Trump administration, the Department of Justice lawyers arguing, well, Judge, there's no need for emergency injunctive relief here. Here's what Judge LaPlante says. This is on page 24. This court has no hesitation determining this situation warrants emergency injunctive relief and class certification. The respondents, the Trump administration's proposed course of action would reverse a nationally known and recognized government policy in place for over a century and affect thousands of families. But wait, Judge LaPlante has more to say on this topic. This from page 32. The putative class would suffer irreparable harm without a preliminary injunction enjoining Trump's executive order. The denial of citizenship status to newborns, even temporarily, constitutes irreparable harm. The denial of citizenship to children would render the children either undocumented non-citizens or stateless entirely. The children would risk deportation to countries they have never visited. The loss of birthright citizenship, even if temporary and later restored at the conclusion of litigation, has cascading effects that would cut across a young child's life and the life of that child's family, very likely leaving permanent scars. Thank you, Judge LaPlante, for injecting some humanity to push back against Donald Trump's inhumanity. Okay, friends, the third and final point. When certifying a class, a judge has to decide if the lawyers, the law firms, the organizations seeking to bring the class action lawsuit are up to the task, are up to the weighty responsibility of representing the rights of thousands, tens of thousands of children. This from page 18. Rule 23A4 requires that the representative parties will fairly and adequately protect the interests of the class. This has two requirements. One, that the interests of the representative party will not conflict with the interests of any of the class members, and two, that the chosen counsel, the attorney, is qualified, experienced, and able to vigorously conduct the proposed litigation. Now, jumping to page 20, the judge says, turning to the second factor of the adequacy inquiry, the court is convinced that proposed class counsel, lawyers from the ACLU Immigrants' Rights Project, the ACLUs of New Hampshire, Maine, and Massachusetts, the Asian Law Caucus, the NAACP Legal Defense and Education Fund, and the Democracy Defenders Fund have sufficient experience and qualifications to serve as class counsel. Now, friends, here's why I wanted to focus on that. I never tell anybody who to donate to or what organizations to volunteer for, but these organizations, the ACLU Immigrants' Rights Project, the ACLUs of New Hampshire, Maine, and Massachusetts, the Asian Law Caucus, the NAACP Legal Defense and Education Fund, and the Democracy Defenders Fund. These organizations are protecting, promoting, safeguarding the rights of thousands upon thousands of children. So friends, I will put links to these organizations in the description of today's video for your consideration. So friends, let's finish where we started. Judges nationwide are protecting us, protecting we the people against Donald Trump's abuse of power. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.